Hello everyone. In this video, we are going to talk about trademark law vocabulary. We cover 10 of the most used vocabularies in trademark law, including trademark, service mark, trademark infringement, generic mark, descriptive mark, suggestive mark, trademark abandonment, distinctiveness, trademark licensing. Number one, service mark. A service mark is a trademark, actually, is a kind of trademark that we use for identifying services rather than products. Service mark important points. Service marks include the requirements of trademarks. For registering service marks, you need to satisfy the same requirements as trademarks. Process of registering both service mark and trademarks are the same. A service mark can carry the standard registered symbol R if federally registered in the USA, while SM is used prior to registration. Service mark is an intellectual property and is protected. As we said, it is a kind of trademark. It is the same. We just use service mark for identifying products. We go into an example. For example, imagine Google. Google have a lot of services including search engine, Google Cloud, Google Colab, and other services. So the name Google is a brand, but actually it is a trademark, but in the essence, we can call it a service mark because Google provides services rather than products. Number two, generic marks. What is generic mark? Generic marks have two meanings in the realm of law. First, generic mark means words or phrases that are generic for a product or service. For example, the word apple for the apple, a fruit. These are general and we call them generic marks. In another meaning, we use it to call some trademarks that, due to their dominance and popularity, are used by people for naming their products. I give you some examples so you understand it more. Generic marks cannot be registered as trademarks because at first, as we said, they are generic and they cannot be specific for a product or service. And the second reason was that for the second type of generic marks, they are going to be named as the name of the product or service rather than any brand that can identify the product or service. As we said, when a generic mark loses its identifying character, we call this process genericide. When a genericide happens, the owner of the brand loses its ownership over that name. A generic mark can be registered in combination with other words or phrases. So at the beginning, it seems that generic marks are not registerable. But if you combine them with other phrases and words, maybe it is possible that you can register them. So we get into some examples to explain more the genericide, which is a process. For example, imagine the aspirin drug. Aspirin in this essence was a brand for a German company. But after a while, people started to call any similar drug aspirin. So the aspirin name lost its meaning for a brand and used to call the drug section. So now the German company lost its ownership over the name aspirin. Another example is the toy yo-yo. Yo-yo was a toy that was manufactured by some company called Duncan Company. As it became famous and popular among people, today we call any similar toy a yo-yo, which is a name for now. But before yo-yo was a brand. Another example is jet ski. Jet ski actually was a brand that owned by a company, a Japanese company. They called a special kind of watercraft a jet ski. But after a while, when jet ski went viral and people used it a lot, people use the name jet ski for any kind of watercraft. So today we call jet ski, which was a brand, and we name this kind of watercraft a jet ski. So the Japanese company lost its ownership over that term. Number three, descriptive marks. Descriptive marks contain words or phrases which describe the characteristics or features of the product or service in sale. I give you some examples. Descriptive marks are weak and difficult to register. So in most of the countries, registering descriptive marks is hard because it is not able to identify products or services. For example, if you name your keyboard that you are manufacturing 104, it is a descriptive mark because in general, keywords have 104 keys. So it's actually describing the keyboard, not using any name to identify it. Other examples are cold and creamy for naming an ice cream, for branding an ice cream, fresh baked for branding a bread, or sweet and juicy for branding any fruit. These are descriptive because ice cream is cold and creamy. Bread is actually most of the time fresh baked, and fruit are sweet and juicy. So these are descriptive. You cannot brand your products related, as we said here, in descriptive way. Number four, suggestive mark. What are suggestive marks? Suggestive marks hint to the product without describing it and without saying that this brand is related to this product. You have to use your imagination to see if this brand is related to this product or not. For example, when you hear the name Apple, you cannot guess that this brand is related to what kind of products. Electronic products like mobiles, like laptops are not related to Apple, and because this relationship is not very descriptive and it is not generic, we call them suggestive marks. Suggestive marks are strong trademarks. The possibility of registering suggestive marks are high, and it is able to distinctive products. For example, you cannot forget that the products of a company, Apple, are called Apple, and you can identify them anywhere you see the products of Apple. And it can create brand identity. You can have an identity with a brand that is strong. So we conclude that suggestive marks are strong and can create brand identity. Another examples are Amazon for retailing company and Nike or Nike for athletic clothes and footwear. Number five, trademark infringement. What is infringement? When somebody uses the same or similar marks for similar or same products or services, that somebody is infringing the trademark. For example, if you use the name Apple for naming your laptop or your phone, this process is infringing the product of Apple or the name or the brand of Apple. The person, that somebody or the person that is using another brand for the same or similar product or services are called infringer. So an infringer do something right, which is using another brand for similar or the same products. Number 6, distinctiveness. What is distinctiveness? Distinctiveness is a character or a criteria that you have to meet for registering your brand as a trademark. So distinctiveness is defined by what? Distinctiveness is defined by a similarity to other marks. If a brand is similar to other marks, it loses its distinctiveness. If it is long and complex, it is probable that it is more distinctive. Suggestiveness. If a brand is suggestive, as we already described the suggestive marks, it is possible and it is probable that the distinctiveness of this brand is strong and it's high. Descriptive marks are not distinctive. They cannot distinctive the product or service from other services. So this criteria for descriptive marks are lost, and we cannot say that descriptive marks are distinctive. Number 7, trademark licensing. Let's define it. Trademark licensing is an agreement that allows a licensee as a person or a company, to use a trademark under certain conditions. So a licensing, as we said, a trademark licensing is an agreement between two parties, two companies, two persons, that they agree to each other that one party uses another party's trademark. For example, we have a famous company that all we know as Disney. Disney is so famous for its dolls, for characteristics and figures that are famous in the whole world. Disney in some point decided that maybe it is a good strategy to license its products to other companies and people that are willing to use its figures. So it is now open to license its products. You can license Disney products like toys, park themes, etc. As we can see that in most of the parts of the world, in most of the countries, we have Disney parks. Another famous brand is Coca-Cola. Coca-Cola is a famous brand for drinking products. It has other parts of this product like its packaging, its bottling and distribution. Coca-Cola is also open to license its brand to other companies and people that are willing to manufacture the drink and also the bottling and the appearance of its products. Number 8, business name. The name that a company uses to conduct business is a business name or trade name. A business name or trade name can be a company's legal name, brand name, or fictitious name. For example, imagine Apple or Disney. Apple or Disney are a brand name. The company can use other names for its company, while other may decide to call their companies also the name of the brand. For example, the name of the company Google is different from the name of the brand. The brand is Google and the name of the company is different. Number 9, intent to use. Intent to use is a requirement in some countries that they make the owners of the trademark or the applicants to show or commit to use their registered trademark for some kind of business or commercial activity. Number 10, Madrid Protocol. Madrid Protocol, which is full name is Protocol relating to the Madrid Agreement concerning the international registration of marks. This treaty allows a trademark owner to file a single international application and seek registration in any country that is a party to the treaty without the need to go to each of these countries and file its application separately. Thank you for your attention.